Hello, all of you. All of us know about how Omar Abdullah was kept under detention ever since August 5th, 2019, when the President of India modified the application of Article 372, Jammu and Kashmir. Yes, he has now been released from detention on March 24th. In this video, I don't intend to talk about the legality of the grounds given by the J&K administration to keep Mr. Abdullah under detention so long, using powers under the CRPC as well as later using the Jammu Kashmir Public Safety Act. Instead, this video will focus on a procedural aspect related to his case. Precisely, I will talk about the delay in legal proceedings at the Supreme Court with respect to Omar Abdullah's detention. So, coming to the case, it's on February 10th, Monday, that Mr. Omar Abdullah's sister, Sara Pilot, had filed a habeas corpus writ petition under Article 32 before the Supreme Court. This petition was mentioned on Monday, that is February 10th, by Senior Advocate Kapil Sibal before a three-judge bench comprising of Justice N.V. Ramanna, Justice Mohan Shantana Gowder, and Justice Sanjeev Khanna. As per Live Law's reporting, this bench had agreed to consider this petition for a urgent fixed date, considering that it is a habeas corpus matter. However, as unfortunate as it could be, till this particular date, as we are speaking, a full-fledged hearing has not taken place in this matter, and hence the petition has not been officially disposed of. Let me break down the timeline for you. So, after filing the petition on February 10th by Sara Pilot, the first major turn of events happened on February 12th, a Wednesday, when Justice Mohan Chandana Gowder recused from hearing the petition. Of course, he never provided any reasons, which reasons for recusing from hearing the case, which I think has now become a matter of normal occurrence at the apex court. I really would like to know what the conflict of interest was for Justice Shantana Gowder to recuse. Like, was he close friends with Omar Abdullah? Did he represent Omar Abdullah as a lawyer while he was practicing as before his elevation to the Supreme Court or the High Court? Of course, I think I've forgotten how the Supreme Court itself has forgotten about concepts like transparency, speaking orders, reasonableness. Anyway, thereafter, this petition, because now the bench could not be complete, this petition was transferred to another Supreme Court bench consisting of Justice Arun Mishra and Justice Indira Banerjee, who took up the matter for the first time on February 14th, Friday, which is 4 days after the petition was filed. Now, on February 14th, Friday, no substantive hearings took place. The court only issued a notice to the central government and the J&K administration and asked them to file a counter affidavit. By the way, this has no problem. This is the routine practice of any petition filed in the Supreme Court. What happens is the Supreme Court will list the petition, issue notice to the respondents in the case, asking them to file a response to the arguments in the writ petition. This is the standard routine practice. The ridiculous part of what happened on February 14th before the court was, after February 14th, the bench posted the matter on March 2nd. It gave that long a time for the government to file a response. Right? So, as per a very funny part, as per online reporting of this case proceedings on February 14th, Mr. Sibal had requested for an earlier date of posting considering that it is a habeas corpus matter. But, of course, the bench did not heed it. As crass as it can get, Justice Arun Mishra's response was, here I am quoting him, if the sister could have waited for such a long period, then 15 days won't make a difference. This is a direct hit on Sara Pilot and an indirect blow by saying that even after 6 months, you thought it fit to file a habeas corpus only now. Right? He was detained, Omar Abdullah was detained on August 5th, 2019. So Arun Mishra's question is, you waited this long to file a habeas corpus, then wait for another 15 more days. Now, this is the most ridiculous way in which Supreme Court has handled or has justified such a long adjournment given in a particular case. That to a habeas corpus case, not any other random rent control act appeal. So it is ridiculous that such a long gap has been given in in a straightforward writ petition like this, a habeas corpus writ petition like this. This is not a complicated matter. Again, let's fast forward to March 2nd. March 2nd, which was a Monday, the government filed a counter affidavit. Thankfully, they followed the dates. Filed a counter affidavit justifying, of course, Omar Abdullah's continued detention. Again, no hearing took place. Why? The matter got adjourned again by the Supreme Court upon Attorney General A.K. Venugopal's submission that he was busy with another case before a special Supreme Court bench. So, even though the matter got listed on March 5th, post March 2nd, the matter next got listed and heard only on March 18th. On March 18th, again, no hearings took place. Instead, the Supreme Court adjourned the matter for another 1 week. Now, this time around, again, the reason for adjournment for 1 week is the non-availability of the next senior-most government law officer, the Solicitor General, Tushar Mehta. Again, the government law officers were unavailable, and the SC did not deem it fit to condemn their lackadaisical approach of the government law officers. Instead, you know what the court did? The court passed an order asking the J&K administration to decide whether they intended to release Omar Abdullah in the coming days. I mean, this is not the routine way in which a habeas corpus writ petition is heard and handled. Habeas corpus writ petitions are all about deciding the validity of detentions till then, and does not merely, become fruitful when the government, after let's say 6 or 7 months, gives a concession and releases that detained person after a while. Right? So, yes. So, essentially, now after this particular day, that is March 18th, this writ petition was never heard. And now it has become infructuous. Why? Because the J&K administration has finally released Mr. Abdullah on March 24th from detention. So all in all, if you look at it from the timeline, February 10th, writ petition filed, till March 24th, around 1.5 months, the SC did not deem a habeas corpus writ petition urgent enough to be heard on a fast track basis. The court also did not, see the need to order either the Attorney General or the Solicitor General or even an additional Solicitor General to appear mandatorily on one of the given days to conduct a full-fledged hearing of the matter. This is despite repeated requests by the Petitioners' Counsel Kapil Sibal to have an urgent hearing in this particular matter. And this is despite the Supreme Court on February 10th, a different bench although, agreeing that this matter deserves to be listed on an urgent basis. You know what? It is, how do I say it? It's always an implied principle of judicial process that out of all the writ petitions prescribed by the Constitution of India, habeas corpus should be given the utmost and highest priority as it deals with matters of life and liberty, isn't it? For example, if, let's say 10 writ petitions are filed today before the Supreme Court, and out of that only one is a habeas corpus writ petition. That habeas corpus writ petition should be heard disregarding all the other 9 ones. That is the level of standard which needs to be applied to the judicial process while handling writ petitions like this. In any way, this is not something new. This case is merely just one another example in the long line of such recent cases where the Supreme Court has made such similar writ petitions infructuous by causing avoidable delays. Mind you, avoidable delays. So, in my opinion, this is nothing but an unfortunate abdication of constitutional responsibilities. Sorry, judicial responsibilities of a constitutional court. So, yes, that's all from my side. Thank you for listening.